Morning, everybody. Week 7, Unit 7, Theme 7. So today we move to the compliance. And as announced earlier, that is sort of the mirror story of the position from the perspective of the government. Let me see. I have some difficulty in finding time to answer the email on the video recordings. So I owe you that. I have to process them first before I can put them in a sort of Dropbox or file share software. So I am working on that. Today we do the compliance, and next week we conclude with sort of outlook, further developments, and that is also a perfect time to look at loose ends, questions you have, exam tips, and the like. So that's the plan. Anything from your side? Are there any urgencies, or people have to leave halfway, or that kind? Yes?
Well, there were one or two pieces of literature that I was not able to download those.
And that is because the link didn't work?
Yeah, there were links to a website. You used 3 or 4 of those links, and they didn't have the file to download.
Okay, so let me look in the break how I can solve it. Yep. Okay, good point. Same. Okay. Well, we are still focusing on the same learning outcomes. We moved to the regulators and the sanctions last week, and I prepared a slide to summarize once more those types of regulators, because I realized that it was sort of between the lines so far. So let me move to that slide. So today we zoom in on the compliance function, and let me first move to the types of, well, maybe I do it like this. Maybe I do repeat that from the governmental perspective, just as a recap, all the actions are under the realm of administrative law. It's sort of base perspective you have to acknowledge. And I repeat, no action, so no design, no establishment of authority, no sanction, no ID is allowed without a proper legal basis. So if the legislative machinery, if the parliament does not speak up, then the market is free to do whatever they want. It's very important. These norms for goods and services and market behavior, they do not come as a sort of infection. They do not fly around. It is a deliberate decision of a legislature. So that is an important. And then each week we realize, we talk about real rules for real goods and services. One side theory, on one side, on the other side, concrete norms that influence the operation of businesses in the market. Then we have 2 types of intervention. We have the broad sense, how do we in general organize the market? And the intervention stricto sensu, that you zoom in on an individual business to punish or sanction or capacity. And then the broad sense intervention is divided from the legislative perspective into those 5 series, with a classic one and alternative one. Classic one, carrot and stick. This is the rule. If you do not follow it, you get a fine. Command. And then alternative modes to influence this market with the aim to avoid market failure. So we've been there. And then the intervention stricto sensu has 2 main flavors since Mr. Braithwaite developed his responsive regulation. The 2 pyramids. So first you capacitate the market actor, the regulatory, You allow it to be in the position to be compliant. And then secondly, you continue to keep an eye on the market actor, and if they fail to comply, you intervene stricto sensu with sanctions. Then the slide I announced. Yes?
I can remember, but a way for just normal civilians to avoid market failure is to not buy the product, right? That was the only way.
The alternative for governmental intervention? Was that your question?
Well, it's not for intervention, it's how to avoid market failure from a customer point of view.
Yes.
It's just avoid to not buy the product. That was the only...
And so when we go... I lost my little sticky to do it remotely. I have to go to the... So, when you talk about... Is it working? When you talk about market failure, you have private choices and public choices. And the private choice is the consumer who can vote with the feet and the purse by not purchasing the goods and services, or by chasing the provider of bad products and services. Suing them, ask compensation, ask a replacement if it is not functioning as a. And so that's sort of the first train station choice. Do I go south or north? If you go south, then you have to abide by administrative principles. Then this is examples of what you actually talk about. Then these are the alternatives. And then if the norms are set, then on the basis of existing norms you can intervene stricto sensu. Then there is a measure stick to hold a regulatory against capacity building and such. Then the types. I introduced a additional type, type 0. That is the judicial approach. Prosecutor, judge. That's sort of side category. But I wanted to include it on the slide, because in the literature it's seen as sort of alternative to the design. But next to that, we have those 4 types. And they are circles away from the central power. Type 1 is the central executive power itself. Federal level, state level. Supranational EU level, member state level. As in, the European Commission itself. Example, fine to Microsoft for market abuse. So the Euro Commission, you read about it in the newspaper, is writing a letter, dear Microsoft, please pay us 500 million euros. The fine. Intervention, stricto sensu. What did they do wrong? They manipulated the market for browsers and operating systems. There's a rule against market manipulation. Don't do that. They did it. Intervention, fine. Example on national level, the ministers and the ministries. So I minister, intervening stricto sensu, and I pose a sanction on it. So that's 1. 2 is the arm's length executive branch. So that you are not talking as a minister, but as a quasi-independent governmental branch. Sort of 4th thing. And that is something that is each time in the news. So today, when it comes to the quality and the market failure of the meat in the Netherlands, so the meat you eat. And market failure with meat is that there's poop on the meat. Remember the bottled water? And so market failure, think of poop. And we don't want poop in the food. And they had type 2 regulation, regulators, and then they privatized them. So they moved to other types. That failed miserably. And now they are reorganizing the regulator. So as we speak, they are debating which type are we choosing to control the meat. So don't think that these discussions are done once and then you're settled. No. Every couple of years, it's back on the agenda. And now the proposal is, let's have the Minister of Agriculture be the regulator. So they are the strongest and the highest in hierarchy. And then journalists say, well, but the Ministry of Agriculture is also the ministry that promotes the meat sector. We export meat. So part of our gross domestic product is earned with selling meat to the world. And the journalist said, it's a bad idea to have the same, the same executive branch. On the one hand, punishing meat producers, and on the other hand, promoting the meat sector. So the proposal is, by this journalist and researcher, let's have then at least the Ministry of Health be the regulator, and leave the promotion of the sector with the Ministry of Economic Affairs and Agriculture. So that at least not in one building, the punisher and the promoter is side by side in one corridor, because that leads to poop in your meat. And so that is the reason why the arm's length executive branch is a solution. And you have a separate building. In Dutch, it's a, in Dutch language, zelfstandig bestuursorgaan, so independent executive branch or institute. With a separate building, separate payslip and so forth, but with state involvement, as in the state establishes it, appoints the head, and asks yearly reports and other control mechanisms. And, very importantly, all those regulators have some sort of state authority to sanction, to punish. And so the whole thing is that we try to channel governmental prerogatives, because it's still a vertical relation to a state company. Alright. Then type 3 is a completely independent body, like a university, or a research center, or the National Central Bank, which is a corporation who controls the money in the state, and then they have, next to that quasi-commercial function, they have a sort of additional task, just by letter, dear bank, herewith we endow you with the power to keep an eye on other banks. So if they misbehave, finish them. Type 3, independent bodies with sort of additional state tasks. And then type 4 is the self-regulation, where the sector is doing it by itself. So that is the lowest degree of governmental sort of involvement. The involvement is that they force practitioners to be member of the self-regulatory body. That's all. 4 types plus a 0 type, the judiciary, prosecutors, and jury.
What is the sector for?
The Association of Traders in Medical Devices, or the cooperative milk producing company, these type of in terms of seeds or elevators. So it is so one type excludes the other. And so maybe, just to be sure, so per type of economic activity, there's one type of regulator. That's maybe important to remember. And so if there is a inspectorate for meat, either being type 1, 2, or 3, and then the Association of Meat Producers is not a regulator. And they might exist, but that's then sort of just a club to have beer and so forth. So the critical thing is whether there's a letter on the table that is endowing that entity with the authority to intervene stricto sensu. That's what we describe from the perspective of intervention. We simplified the task of each of these regulators to the so-called job description. So all those types of regulators do the same thing. Gather information about the question whether goods and services comply with the set rules, form a legal opinion about that information, right or wrong, and then eventually intervene with the sanction pyramid. And that's what we call in this course the job description. So the self-regulatory body has that job description. Is the attorney rendering correct legal services? Yes or no? And if no, what sanction do we have? Well, the severe sanction is disbar the attorney at law. For the minister, for the European Commission, is Microsoft complying with the rules pertaining to competition in the market, misuse of market power, and forcing us all to use Windows? No. Intervention, stricto sensu, fine, 500 million. Next year they still did it, another fine, 500 million. And that's the job description we took. In the sanctions, it's easy. Two types, restorative and punitive. Restorative to fix the failure, punitive to have a sort of deterrence effect, decapacitate the culprit, the non-compliant regulatory, in the sense that in such a situation he can do it again. The topic of today, compliance. Three aspects: the context, the positioning of the compliance officer, very important and crucial, and then the tasks. The context. The word comes from a verb, to comply. So it's the noun of a verb. And to comply means to align, to follow up, to adhere to the wish of someone else. The history of the word compliance officer is connected to the stock market industry. So the first sector, ladies and gentlemen, so which sector is connected to the history of the compliance officer? So stay focused. And the idea was in that sector that no one understood what was going on. So there were sort of rules said, please do not trick the investor. And having the investor purchase shares in companies that promise perpetual mobile or trips to Saturn or black tulips or other fancy products that cannot exist. And the idea was, well, if then in those companies a specific officer is taking care of the compliance, that rule, and then hopefully, fingers crossed, this sector does not produce market failure. So they were the first to do that. In the United States, in the European states. And then that grew into a sort of specific sort of job profile in those companies. With a business card, with the name compliance officer, like accountant, like in-house counsel, like marketeer, like sales officer, like designer. And so it became a profession. And then all the other sectors in the economy, housing, food, medicine, services, transportation, they realized, well, we are in the same boat. we are also regulatories. Our goods and services are influenced by norms that shape them. So also we need maybe people that have as specific task in the company the task of keeping an eye on those norms. It is closely related to another type of officer you already met this quarter, that is the risk officer. And basically, the name doesn't matter. So, risk officers are indirectly compliance officers, and compliance officers are also risk officers. And when companies are very big, and they have both risk officers and compliance officers, then they have to divide the tasks. And we will look at the task of a compliance officer, and then you will see where those two officers fit in together. So from a theoretical perspective, there is no real difference between a risk officer and a compliance officer. Having said that, if you ask a risk officer, are you the same as a compliance officer? He said, no, I'm completely different. And when you ask a compliance officer, are you the same as a risk officer? No, no, no. And it has to do with salary, social status, the type of diplomas they have, and so forth. And there's no science on that point. But as a preliminary theory, I would dare to say that the risk officer is the sort of engineer or accountant that grew in the job and got more responsibility. And the compliance officer is the more general educated lawyer, higher education type, who from sort of board level, top down, is hired to do the same thing. But that is just a preliminary theory, that the risk officer comes from the operation and is lifted to a more responsible position, so bottom up, and the compliance officer is hired more from a board top down perspective. But ultimately, they do the same. Maybe that is a topic for a bachelor thesis one day or another activity. And the professional context is further completed with specific training programs and specific degree programs. And so you can have certain diplomas in compliance officer or risk officer activity. Okay, who do we talk about? To understand the proper position and responsibilities of a compliance officer, we have to do an intermezzo. And the intermezzo is corporate law. The best way to understand what a compliance officer, risk officer really is to understand the basics of corporate law. And the good news is, those basics are very simple. 200 years ago, in the United States, in European countries, a legal trick is created. A legal trick around something that economists call the coordinated cooperation of capital and labor. A business, a enterprise, a company, being a phenomena in society where capital and labor is fused, organized, and producing goods and services. So let's take a plane from Mars and visit planet Earth and look at societies. And then you see governmental agencies, you see private individuals, and you see something we call business. Okay. And that business is connected to a legal trick. And the trick is that those businesses were endowed with what lawyers call legal personality. By a fiction of law, businesses